Good morning, everyone. My name is Christy McKenzie. I am the Assistant Coordinator for the Department of Erie County Department of Senior Services. A few things to mention. We are recording this event today so you can view it later. It should be available on our website shortly. Also, you can feel free to use our Q&A panel, which is on the right-hand side. All questions will be anonymous. Only the presenter and myself will be able to view the questions. I would like to thank our County Executive, Mark Polenkars, our Commissioner of Senior Services, David Schenk, and our partners and CEO, Karen Nicholson, for the Center for Elder Law and Justice for making our 2020 Virtual Elder Law Day Summer Series possible. Also, when you ask questions, please remain anonymous. Do not put any personal information into the questions section. So this series will continue through the summer, covering a variety of interesting topics. Please be sure to register and tune in every Wednesday. You can find more information at erie.gov/ELD. Okay, so today we have Jamie Smith. She is a partner in the firm of Smith Vavonese. She received her Juris Doctor in 2003 from the University of Buffalo Law School and her Bachelor of Arts degree, magna cum laude, from the State University of New York at Brockport, New York in 2000. Jamie concentrates her practice in the areas of trust and estate, planning, elder law, estate administration. Jamie is currently served on the Board of Directors for the Center for Elder Law and Justice. Jamie is also a member of the Estate Analyst of Western New York. She is also a member of the Elder Law and Practice Procedures and Surrogate Court Committee of the Erie County Bar Association. Today, Jamie will be speaking about the benefits of irrevocable and pooled trusts. Welcome, Jamie.
Thank you, Christine. Welcome, everybody. So as Christine mentioned, we are talking about two different types of trusts today. And just so you know, there's lots of different types of trusts, but we're really going to just focus on two in particular. The first one is a Medicaid Asset Protection Trust, which is a type of trust that people use when they have assets that they're trying to protect from long-term care costs, whether that's at home or in a nursing home. So as an elder law attorney, when I meet with a client for the first time, their primary concern is, how do I pay for my long-term care costs and not spend everything I've worked my entire life on the cost of that care? So in order to explain to them what their options are, it's first important to understand how long-term care insurance gets paid for. So when we turn 65, our primary health insurance is Medicare, but Medicare has a very limited benefit to cover nursing home care. If you're admitted to a hospital for 3 days, and the key is being admitted, because now what happens and what we see is that people are put on observation status, which means they're not technically admitted to the hospital. But if you're admitted for 3 days and then you're discharged to a nursing home for rehab, Medicare will cover a maximum of 100 days for that rehab stay. Days 1 through 20, it covers 100%, and days 21 through 100, it covers 80%. That's assuming you're lucky enough to get the full 100 days. What we typically see is people are cut off prior to that time because the physical therapist determines that you've plateaued. You're no longer, getting better, or you're not participating. When that occurs, but you still need someone to help you with all your activities of daily living, like transferring or bathing or dressing, or maybe you have a cognitive issue and it's not safe for you to be home alone and you need someone to supervise you 24 hours, 7 days a week, they will transition you from the rehab side of the facility to the long-term care side. At that point, Medicare does not cover that stay. So how do we pay for that stay? Well, if you're lucky enough to have long-term care insurance, then you file a claim. And most long-term care insurance policies have a 90-day elimination period where you're responsible for the first 90 days, and after that, they start to pay out the daily rate. Some policies will reimburse you after you submit proof that you've paid, and some will pay the facilities directly. The problem that we see with long-term care insurance, and I always encourage my clients to look into it and to price it out, but the problem that we see is that it's costly to purchase. For a relatively healthy 60 to 65-year-old today to get a comprehensive long-term care insurance policy, which will cover what it actually costs to be in a nursing home, you're looking at between $5,000 to $7,000 a month, or excuse me, a year in premiums. And that's per person. So if you're a married couple, that can range anywhere from $10,000 to $14,000, which is pretty expensive. And you pay that premium indefinitely until you either go on claim because you go into a nursing home or assisted living or need care at home, because long-term insurance will cover that as well, or until you pass away. So if you never need care, like any other insurance, you've paid those premiums for no reason. In addition, what we see is that you may not medically qualify for long-term care insurance. If you have a diagnosis of Parkinson's or dementia or cancer or anything like that, it's very unlikely that you're going to qualify medically for that coverage. Even our younger clients who may need a knee replacement in a couple of years or a hip replacement, we've seen them be denied by the underwriters because of that. What we also see is that people come in and say, oh, I do have long-term care insurance. And we say, that's great. We want to take a look at your policy to make sure your coverage is sufficient. And what we often find is that they may have a policy where they, the daily benefit for nursing home care is only $250 a day. Well, in reality, a nursing home costs $450 a day. So they still have a shortfall between what that cost will be and what that benefit provides. So their assets and income are still exposed. The other thing I'm going to say about long-term care insurance is that a lot of my clients who purchased it a long time ago are now receiving premium increases. They're being told, if you want to keep the same coverage that you got when you first purchased this policy, your premium is going to increase, and sometimes substantially. In some cases, it has doubled. And so what they will often do is they will elect to reduce the inflation rider, which they had put on the policy when they first purchased it, so that they don't have to pay that increased premium, which just means that daily benefit is not going to keep up with the cost of care. So if you don't have long-term care insurance, and many people do not, well, certainly when you're transferred from the rehab side to the skilled facility, you're expected to privately pay. And that's probably, as most of you will agree, the least favorable option. You'd have to use your assets and income. As probably most of you know, an average nursing home on the low end in Western New York is about $11,000 a month, and on the high end, it's about $15,000. So you can see how quickly your life savings would be depleted if you were to privately pay for that care. So the third option is Medicaid. And in order to qualify for Medicaid, you have to be at or below certain resource allowances and income allowances. For nursing home care, there's a 5-year look back, which probably most of you have heard something about. So when you go in to apply for Medicaid to pay for your nursing home bill, the county says, okay, show me everything you've done with your assets over the last 5 years. And like forensic accountants, they go through and they say, where did this money go? Did you write a check to your child? Did you gift money to your grandchild? And they add up all of those gifts within that 5-year period, and they impose a sanction against you if you did give away assets. So what are those resource allowances? Because this is what people are most concerned with. It really depends whether you're married or you're single. So for a married couple, if there's a spouse who's living in the community, we call that person the well spouse. He or she can keep a minimum of $74,820 in assets up to a maximum of $128,640. In addition, the spouse that's in the nursing home can keep $15,750. The spouse that's in the community can also keep the home, as long as its value doesn't exceed $893,000, which typically is not a problem in Western New York. The other big thing, retirement accounts. So that includes IRAs, 401ks, 403bs, etc. If they're in payout status, which now the laws have changed so that when you're 72, you have to start taking distributions and put them into payout status. Once that occurs, those are exempt as a resource as well. So you could have $2 million in an IRA and still qualify for Medicaid as long as you're taking distributions from it. And that's huge. That's really unique to New York. One vehicle is also exempt for the spouse that's in the community. It could be a Rolls Royce, really, they don't care. If you have life insurance that's term, which means it has no cash value, that's exempt as well. If it does have cash value, if the face value is under $1,500, that's exempt. If it's over $1,500, they look at the cash value and they count it towards the $74,000 and the $15,000 that you're allowed to keep. The county also allows you to prepay for your burial. So any monies you put into an irrevocable burial account through a funeral director are considered exempt, and in addition to those resource allowances we just went through. So what if you're a single individual? Well, you're only allowed to keep the $15,750 and any retirement account that's in payout status. Same exemption for the life insurance that we just talked about. And if you're living in the community and you're seeking what we call community Medicaid to pay for home care or daycare, then the primary residence is also exempt, as well as a vehicle and your burial account. So what I do with clients when they initially come in is I ask them to give me a list of all their assets. How much do we have in the bank? How much do we have in retirement accounts? How many properties do we own? And based upon the numbers that we just went through, I do an analysis for them. And I say, okay, here's what you have that's considered exempt in scenario one, where you're a married couple, one of you's at home, one is in the nursing home. Here's what's exempt, here's what's exposed. And if there are assets that are exposed, here are things we can do to try to protect them. This Medicaid Asset Protection Trust, which is also known as an irrevocable trust, is the primary planning tool that we use to protect those assets. By putting some of those exposed assets into that trust, we're starting a clock ticking. So 5 years after those assets go in, they're protected from ever having to be used to pay for nursing home care costs. Currently, we don't have a look back for the community Medicaid waiver programs that provide the home care. That being said, the governor has implemented a look back, which is going to begin for any transfer made on or after October 1st, 2020. And that's going to be a 30-month look back. So if people are concerned about, getting coverage for these community Medicaid programs, they really should think about doing some planning prior to that date. The other advantage of using this type of trust is that it avoids probate. So I'm sure some or all of you have had some experience with probate. That is the process that when we pass away, if we have assets that are just in our individual name, so they weren't joint with somebody, they didn't have a beneficiary, they have to go through the court and through our will, if we had one, in order to get to the beneficiaries we want to leave it to. That involves the court, that involves an attorney, that involves filing fees and legal fees and time delays. So if we can avoid that, that's usually in our best interest. So how does this trust work? Who are the players of the trust? Well, the client is typically the grantor, because that is the person who's setting it up and whose money or property that's exposed that are going to be put into the trust. And really, any individual who's over 18 years of age can establish this type of trust. There is no disability requirement for an individual to set up this type of trust like there is with pooled supplemental needs trust, which we'll get to in a minute. So you can come in and be perfectly healthy and say, we want to be proactive and start a clock ticking on our exposed assets. Or you can say, hey, my spouse was just diagnosed with Parkinson's and we want to make sure we start that clock ticking. Then there are the trustees. So typically my clients will have one or more of their children act as trustees. Trustees can be individuals or they can be corporate trustees like banks and other financial institutions. The trustee is a fiduciary and they're legally responsible for investing the money that goes in there, making distributions of income and principal to whomever are named as beneficiaries. And then we have the beneficiaries of the trust. So these are usually individuals or charities, organizations who are entitled to income and principal during the client's lifetime and then ultimately at death. And you can have beneficiaries who are entitled to money during the grantor's lifetime who are different than the beneficiaries who receive it at their death, totally up to the client. So how does the trust work? Well, once the assets are put in, the client decides when setting it up whether they want to receive the income from those investments. Some of my clients say, you know what, I have enough income coming in from Social Security and pensions and IRAs. I don't really need this income from, my investment account. I just want to accumulate that income and reinvest it because that's what I'm doing right now. So the trust can be structured to accumulate the income or pay it out to the grantor, depending on their preference. The principal on the trust, which is any amount above and beyond what the income is, can be paid to third parties like children or grandchildren during the grantor's lifetime if they want, but not to the grantor or the client. That is how we keep it unavailable to pay for their long-term care costs. If the trust said any amount of money that goes into the trust can be paid back to the grantor, the county would say, well, that's terrific. It should be used to pay for their nursing home. And that's what we're trying to avoid. And then at the grantor's death, whatever monies are remaining in that trust get paid to their beneficiaries, either outright or it can be held in further trust for minor children or grandchildren. It's very similar to how a will gets distributed, but there's no probate required. So what goes into the trust? How do we fund the trust? When I sit down with clients, I say, okay, here's what's protected if one of you needs care, and here's what's exposed. And based upon that, here's what I recommend you put into the trust. We also take a look at what are the client's monthly expenses and what is their monthly income from Social Security, pension, etc. If they have a surplus every month of income because their income is more than enough to cover those expenses, sometimes we put in more than what's exposed just in case we ever get to scenario 2, where what happens if one spouse passes away and then the surviving spouse needs care? Because in that scenario, the property is no longer exempt. There's no spouse to give the $74,000 resource allowance to, so there's usually a lot more exposure. If, however, their monthly income is not sufficient to cover all their expenses and they're living off of the dividends and interest on their investments, then we typically structure the trust to pay income to them. But in terms of what types of assets can go into the trust, really it's just about anything. People will put their house in, they'll put other real property that they own, they'll put stocks and bonds and bank accounts and cash and mutual funds. They could even put in non-qualified annuities. The only thing that really can't go into the trust would be retirement accounts, but those are already considered exempt assets when they're in payout status, so there's no reason for that to go in. Okay, so the other concern is if the trust is an irrevocable trust, that means it's set in stone once I set it up, right? I can never make any changes to it. That's scary. I don't like that. Well, that's really not the case, because if it's drafted properly, there's a lot of flexibility. There's a lot of discretion that you have when setting it up. So we typically structure the trust so that the client retains what's called a limited power of appointment, which means at any time they can change who the beneficiaries of the trust will be. So if they have a falling out with one of their children or someone becomes disabled, etc., they can make changes to those beneficiaries. They also can change who the trustees are. So again, if they appoint their children and they have a falling out with one of them, or they decide, one of the kids decides, hey, I think that we should invest it this way, Dad, instead of this way, you can remove the trustee and replace them with anyone else. Finally, and most importantly, I think, even though the trust is irrevocable, under our New York Estates Powers and Trust Law, and that's section 7-1.9, if all of the interested parties to the trust consent, an irrevocable trust can be amended. It can be partially revoked, meaning we can return a specific dollar amount to the client, or completely revoked. So the interested parties are whoever is named on there as beneficiary and the grantors of the trust. Now, if a child who's a beneficiary says, no, I'm not going to agree to partially revoke the trust because that's my future inheritance, well, with a limited power of appointment, you have the flexibility to remove them as a beneficiary. So the trust really can be manipulated by the grantor because of those powers to do anything that they might need to do. So clients will ask me, what's the advantage of using an irrevocable Medicaid asset protection trust versus just giving assets outright to their kids? Well, in both scenarios, we start the clock ticking. If I just say to my kids, here's $100,000, keep it in an account in your name, and if I ever need it, you know, you promise that you'll give it back to me. By doing that, or by setting up this trust and moving assets in, that starts the 5-year clock ticking. What's different is if your child then is sued because they're in a car accident or files for bankruptcy, their creditors can go after that money if you just gave that money outright to them, whereas the trust insulates from those creditors' claims. So your kids' creditors could never get at the money when it's in the trust. When you make an outright gift, your kids can really spend it, do whatever they want with it. I mean, hopefully that's not the case, but stranger things have happened. If you have a falling out with them, you know, they may not give it back if you need care within the next 5 years. But with the trust, you can always change the beneficiaries. So it's not really theirs until you're gone. You can also limit how they spend it to a health education maintenance standard when it's in the trust. You can change the trustees. And more importantly, from a tax perspective, if assets are in a trust, like highly appreciated assets, such as stocks or real property, your kids will get a step up in basis at your death if they inherit it from the trust. So what does that mean? So let's say you bought stock for $20 a share, and now it's worth $50 a share. At your death, if it's still worth $50 or whatever it's worth at that time, that's what your children's cost basis becomes if they ever want to sell it. Whereas if you just gave those stocks to your kids, did an outright transfer to them, their cost basis is what your cost basis is, the $20. And if they ever sell it, they're going to pay capital gains tax. And that's the same for real property as well. That's true for everything except for annuities and savings bonds. Those always grow tax deferred. You don't get a step on those, whether they're an outright gift or in the trust. With the trust, all of the income that's earned on the investments in it still get taxed to the client or the grantor. And that's good because most people who set up these trusts are retired and they're going to be in a lower tax bracket than their kids are. Because if you just gave them assets outright, and they, you know, are investing it under their Social Security number, they're going to pay the income tax on that. Disadvantage of doing a trust is certainly it's more involved than an outright transfer. It's more costly to set up in terms of legal fees, and it can be a little more complicated to administer than an outright gift, obviously. So now we're going to switch gears and talk about pooled supplemental needs trusts. And there are lots of different pooled supplemental needs trusts, but we're going to specifically talk about the Western New York Coalition Pooled Trust, which is our local pooled trust. And that is administered by Center for Elder Law and Justice and People, Inc., who are the agency trustees. And KeyBank is the corporate trustee. So obviously, and this applies to the Medicaid Asset Protection Trust portion of the webinar, this information is really just for informational purposes. Everyone's situation is different, and really we would need to take a look at your specific information to give you accurate advice. So that's just our disclaimer. So what is a pooled trust? So a pooled trust is a type of supplemental needs trust. And what a supplemental needs trust is, it's a special type of trust that is for disabled beneficiaries. You have to be disabled. And it's meant to enhance the quality of that disabled person's life. So what does that mean? Well, if a person is disabled and receiving Medicaid or SSI, we know that there are asset and income limitations to qualify for those programs. Congress realized that it's difficult for a disabled person to remain in the community and live on $875 a month in income, or only be able to have $15,000 in the bank. So basically, Congress carved out this exception and said, if you're disabled, you can put money into a supplemental needs trust, whether it's assets or income. And that money can be used to pay for things that your government benefits don't cover. In this case, a pooled trust has multiple beneficiaries. So it's not just a trust for one person or one disabled person. And there's a master trust agreement, and the disabled people sign a joinder agreement to join the master trust. And they all have what are called little sub-trust accounts, where their money is kept separate, but they're all part of the pooled trust. And it's also that those resources are pooled together for investment purposes. So what are the eligibility requirements to enroll in a pooled trust? Well, unlike the Medicaid Asset Protection Trust, the person must be disabled. Typically, if you're receiving Social Security disability, that's definitive proof of disability. If, however, you're over 65 years of age, you're going to receive regular retirement benefits from Social Security, even if you were receiving disability prior to that age. So the Medicaid regulations say that there has to be a determination of disability made for anyone who wants to enroll the pooled trust who's over 65. Unless you were receiving the SSD and SSI prior to that and you provide a letter from Social Security, most counties say that's sufficient. They won't make you go through the separate disability determination. For most of my clients, their disability did not come to fruition until after age 65 because they either had a stroke or were diagnosed with dementia or Alzheimer's or Parkinson's, etc. So most of them do have to have that paperwork filled out and submitted to get the disability determination to enroll in this. And really, the paperwork involves a one-page form that the Department of Health requires your primary care physician to fill out. And then there's a separate disability questionnaire that the client or family fills out. That paperwork is provided to the caseworker at Medicaid, who then sends it down to Albany for the disability determination. And they have 90 days to make that determination. So again, why would an individual need or want to use a pooled trust? Well, as we stated, it's very difficult to live on $875 a month and keep only $15,000 in the bank. And if you're on SSI, you're only allowed resources of $2,000 as a single individual or $3,000 as a married couple. So this again is a vehicle to keep assets above those limits or income above those limits. It also allows the disabled person to remain at home. If we can afford to pay our rents and we can afford to pay our utilities and stay at home, that's better than being institutionalized, obviously. And then we can maintain the quality of life that we want. And we can achieve both of those things without the complete loss of our resources and income. So there are two types of pooled supplemental needs trusts. The first is called a first party trust. And that means it's established or set up by the disabled individual. And it's his or her income and assets that go into the trust. If the person is under 65 when they set up the trust, there's no transfer penalties for Medicaid or SSI, even if they, need nursing home care after they turn 65. If, however, the person sets up the first party trust after the age of 65, transfer penalties can be assessed by the county if they go into a nursing home. In either scenario, whether it's an under 65 or over 65 first party trust, the trust ends when the disabled person passes away. But what's different between this trust and the Medicaid Asset Protection Trust is that any monies that remain in the trust at the time the disabled person passes away have to remain in the trust. It can't be paid to their family members, their estate, etc. And that's what Congress said. We're going to allow you to keep additional income and assets, even though you're getting these public benefits. But the catch is, if there's money left in your trust when you pass away, it either has to go back to the county or the state to reimburse it for any Medicaid that was paid out on your behalf, Or with a pooled trust, it can stay in the trust to benefit other disabled beneficiaries, which is kind of nice. The second type of pooled supplemental needs trust is a third-party trust, and it's established by a third party. So like a parent of an adult disabled child might set one up, or a grandparent or other family member or friend. And that person contributes his or her own money. So it's not the assets or income of the disabled beneficiary that's going into the trust. Some clients will set this up during their lifetime and put some money in for their, children or grandchildren, and others will just have it set up through their will. They'll direct money to go to this trust when they pass away. What's nice about the third-party trust is that there is no payback to the county, and only 15% of what's left in there remains in the trust. The other 85% can be distributed to whomever that third party directs when it initially gets set up. So it could be, if it's a parent, it could be their other children, or it could be other grandchildren, etc. So what type of assets or money do we put into the pooled trust? Probably the biggest thing that I see in my practice is the excess income. So if I have a client who's applying for Medicaid in the community, we know a single individual can only keep $875 a month. If they have a pension of, $800 and they get Social Security of $1,000, we know they're over that income limit. So the options are, Medicaid will say, we're going to approve you for coverage, but you have what's called a spend down. And any income above that $875, you either have to pay to the county, and then we'll pay 100% of your medical bills, or you can prove to us that you've incurred medical bills that equal that spend down amount, and then we'll activate your Medicaid, which is a pain. Or the third option is you can divert that excess income into this pool trust. And by doing that, basically Medicaid is paying 100% of your medical bills, and that income can still be used to help keep you in the community and pay for things for you. The other thing we see often is a direct inheritance. If a parent didn't do any planning and at their death, they just leave money to their disabled child, that's going to kick that disabled child off of government benefits. So that child can set up the first party pooled supplemental needs trust and put the inheritance into it. The other thing we see, as we talked about, is the parent did say, okay, I want to leave money to my disabled child, but I don't want to kick them off benefits. And I want to direct that if there's any money left in that trust when they pass away, it goes to my other children. So they can set up the third party trust through their will. Gifts. Again, maybe it's something the parent wants to give to the child now during their lifetime, but they don't want to ask a sibling to be the trustee and manage it and do a private trust. So the pool trust, because there's People Incorporated and Center for Elder Law and Justice, who are the agency trustees, there's a guarantee of continuity of the trustee. Because if we have children that are similar in age, maybe the child who's not disabled, who's acting as trustee for his brother, passes away or becomes sick. So if a parent's concerned, or maybe they don't have anybody else that can act as trustee, the pool trust is a great way to ensure that that money will be managed for that disabled beneficiary. Sometimes people will receive retroactive Social Security awards and they put those in. Or personal injury settlements if they're in a car accident or, whatever, or a structured settlement. If they get a monthly payment from an annuity, they can put that in. And sometimes people just have excess resources and want to qualify for Medicaid. But I always caution people to look at a Medicaid, asset protection trust versus a pooled trust for excess resources, because again, if they need care, nursing home care, and they're over 65, there could be transfer sanctions for that. With the Medicaid Asset Protection Trust, it can be revoked if everyone signs off on it, and other planning can be done if they need care within that 5 years. Okay, so what can the pooled trust be used to pay for? What are the eligible disbursements? And really, this is broken into two categories. First, we have those clients who are not getting SSI benefits, because SSI is supplemental security income. And this means, that benefit is intended to pay for food and shelter expenses. So if a client is receiving Medicaid only to pay for home care or medical expenses, then the trust can really pay for just about anything with a few exceptions. So rent to their apartment or wherever. If they have a mortgage because they own a house, they can pay for that. Or condo maintenance or insurance, homeowners or renters insurance. It can pay for ordinary repairs and maintenance to the property, property taxes, school and county taxes. It can pay for utilities and furniture. And it can also pay for your burial arrangements. It can pay for groceries, car payments or insurance, adult diapers and other items, personal needs, anything else that the trustees determine is appropriate for the beneficiary. It can also pay for transportation or vehicle expenses if it's owned by the beneficiary. So if a client is receiving, yes?
Oh, we have a question. I thought it'd be a good time to ask a question.
Sure.
Okay with the question?
Absolutely.
What happens if the beneficiary chosen has also passed away? Does that stay in the trust?
What happens if the beneficiary's children passed away?
The beneficiary who was chosen also passes away.
For a pooled supplemental needs trust?
Well, that's when the question came in. It just says that, does that stay? Oh, for the third party.
For the third party. So basically, if I'm the parent setting up the third party for my disabled child, I'm going to say, this money is available for my child as the beneficiary during his lifetime. And when he passes away, here's how I want that 85% to be distributed. So the person, the third party who's setting it up, directs at that time when they set it up or in their will, what happens to any money left in the trust, that 85% that they can designate, where that should go. So they get to decide that. They have to decide it if they're setting it up during their lifetime at that time, or they have to specify that in their will.
Okay.
Okay.
That's it for now.
Okay. So for clients who are in receipt of SSI benefits, which again is intended to pay for food and shelter, the trust is limited as to what it can pay for, because the purpose of a supplemental needs trust is to supplement what government benefits are paying for, not supplant them, not replace them. So it can pay for things like a vacation. You want to go somewhere, including airfare, hotels, etc. Furniture, any type of adaptive equipment that might be necessary for the disabled beneficiary. Transportation, computers, gym memberships, education. If the person wants to go back to school, get a degree, they can certainly do that. An SSI recipient's also entitled to have a car, so it can make car payments or pay for the insurance on the car. Sporting goods, again, the burial accounts, and any non-food or shelter expenses. So that would include, a cell phone or a landline, cable, internet, those types of things. How do you request a disbursement from the trust? So any purchase that you want the trust to make once you're enrolled into it has to be pre-approved. So you can't go out and purchase something and then say, hey, I want to be reimbursed for this. You submit a form, and it can be emailed, faxed, mailed, or submitted on their website with supporting documentation. So if you say, I want to purchase this new car or, washer and dryer, you're going to go to Best Buy and say, tell me what this is going to cost for this washer and this dryer. Or you're going to go to the dealership and say, give me an estimate of what this vehicle is going to cost. The pooled trust will also pay for home care. If Medicaid says we're only going to approve you for X number of hours a week and you really need more than that, you can use the money in the pooled trust to pay for it, but they're only going to provide licensed companies. So in addition to home care, they will pay somebody to snowplow, lawn care, but they have to be not your friend. Okay, so what is prohibited from being paid from the trust? Cash. The trust will never give you cash. Now remember, you're allowed to keep $875 a month from your income. You can do whatever you want with that. The trust cannot give you cash because that'll put you over the income allowance and you'll be ineligible for benefits. It will not pay for gifts for your grandchildren or anybody else because it has to be solely for your benefit. Any disbursement that comes out has to be solely for your benefit. If you own a house, the trust will not pay for capital improvements to the property if it's not owned by you. What does that mean? So a lot of my clients have what's called a life estate in their real property, meaning they own it for their lifetime, and at their death, it goes to remainder owners, their children typically. If you have your property already set up that way, and you need a new roof on that house, the trust is going to say nope, because that's going to benefit the 3 children or whoever you have on there when you pass away. So we won't do capital improvements if you just have a life estate. The trust will not pay for rent and mortgage and property taxes because if you own the property, you shouldn't be paying rent as well. It typically will not pay for items that are covered by government benefits. If Medicaid will pay for a medical procedure, it's not going to pay for that. Now, I've had some clients who have had to see doctors or dentists where Medicaid they don't accept Medicaid. They won't cover that. So the trust can be used in those situations. It also will not buy alcohol for you, firearms, or anything that's considered illegal, which is kind of common sense.
We have another question about disbursements, Jamie.
Sure.
For a disbursement, if it does not receive pre-approval, do people have the right to appeal it and provide proof as to why they think it should be approved?
They certainly can ask for them to, look at it again, but it basically says when you sign the joinder agreement, you're acknowledging that you have to get pre-approval before any disbursements are sent out. So that's a contract, that's a legal contract. So it's unlikely that person would be successful in overcoming that or appealing that, unless maybe it's like an emergency situation. I could see, something that they would have approved and it was an emergency and they weren't open, but typically in my experience, you have to get prior authorization. And that's, discussed up front before you even enroll in the trust.
Okay, that's the only question for now.
Okay. So the final prohibited disbursement is really, I guess a lot of people ask for this. Can you purchase a car, put it in my daughter's name because she takes me to the doctor, she takes me to the store? That can't happen either. It has to be in the disabled beneficiary's name. Okay, so how do we get to apply for the pool trust? Well, first you have to apply for Medicaid and be approved and receive what's called a notice of decision saying you're approved, here's your spend down. Or, if it's you want to put assets in there, you're approved, but you have excess resources of whatever. Then you need to complete and submit the disability paperwork to your caseworker if that's necessary. Again, that's only if you're over 65 and you weren't previously receiving SSD or SSI and have that original award letter. Then there is an application that the client fills out and submits that with proof of their income. So like a letter from Social Security, pension, IRA, the letter from Medicaid, the disability letter from Medicaid, and then they have what's called an authorized contacts form. If you want to have your power of attorney or your children be able to contact the trust and submit disbursement requests on your behalf and deal with them for you, you can fill out that authorized contacts form and submit it. And if your child is power of attorney or guardian for you, that also needs to be submitted with the paperwork. And then finally, that joinder agreement. So that is the contract where the disabled individual says, I want to join the master trust agreement. And Western New York Coalition Trust requires that the disabled individual or their power of attorney or guardian meet with an attorney to review that contract and everything that's involved with the pool trust so that they're, going into it eyes wide open and understand the ramifications of it. So if you are interested in getting an application to enroll in the trust, you can call. There's a 1-866 number, or you can go onto their website, which is terrific. There's tons of information on there, everything I told you and more. And it tells you, specifically under 65, over 65, and third party. or you can email them and they can send you information that way. So the last thing I want to talk about is, how do these two trusts come together? How can we utilize both, or is that not possible? And really, you can. What I see a lot in my practice is I will have clients come in and they'll say, okay, we want to set up a Medicaid asset protection trust to protect our assets that are exposed. And we'll do that. And maybe a couple of years later, someone is diagnosed with something, or somebody who was diagnosed when we initially met has gotten worse and is in need of home care. So in that situation, we've protected the assets, but the income is still exposed. And a Medicaid asset protection trust can only protect assets. It can't protect income. So at that time, we'll set up a pooled supplemental needs trust to protect that person's income so that they can still remain at home, have Medicaid pay for that care, and keep all their income to pay for their utilities or other expenses. So the two really can be used in, conjunction with each other. And that completes my presentation. So I don't know if anyone has questions about either types of trusts or anything else that maybe I did not cover that you have concerns or questions about, but I'm happy to take questions now.
Let's give them a second to type them in if anybody has anything.
Okay.
And Jamie, do you want to read off your contact information? Some people, I think, are calling in, so just so they can't see the slides then.
Sure. And if anyone wants a copy of the PowerPoint, I'm happy to provide email or mail that to you. My office is located in Orchard Park. Currently, the address is 220 Red Tail Road. We're in Suite 5, and that's Orchard Park, New York, 14127. And my phone number is 716-257-1241.
Okay, so I don't see any more questions, Jamie. Thank you for taking the time to join today. I hope everyone learned a whole bunch of new information. Thank you, everyone, for joining as well. And there will be a brief survey that should pop up shortly. If you could fill that out, we'd appreciate it. And also, I hope that you will join us again next Wednesday. Our topic will be elder abuse. What is it? What is being done to stop this growing problem? So we hope to see you all back next Wednesday. Thank you. Thank you, Jamie.
Thank you. Bye-bye.
Bye.